On this week's episode of the Crushing Debt Podcast, how many people live in your house?
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law, and we have some continuing changes here on the show, and I'm happy to bring them to you. Now, one thing that hasn't changed is our relationship with our sponsor, Sam Cohen of Attorneys First Insurance. Now, Sam writes errors and omissions insurance or malpractice insurance for attorneys and title companies all over the country. Now, he has a particular focus on Texas and Florida, but he can literally write an insurance policy for any attorney or title company that needs professional liability coverage anywhere in the country, really. So a great referral for Sam would be an introduction to a new attorney starting his own law firm maybe, or even a new title company that's just trying to start and get up off the ground. Sam can write errors and omissions insurance or malpractice coverage for that startup law firm or startup title company. And if you're an existing law firm or title company and you just want an apples-to-apples comparison of what do you have now versus what Sam can provide, he'll give you an estimate, he'll give you a quote. So you can reach Sam at his website, which is attorneysfirst.com, or you can reach him at his email, which is sam@attorneysfirst.com. But I want to mention someone else who has been as big a supporter of the show, if not a bigger supporter of the show, if that's possible, than Sam, and someone who I've really failed to mention, and I apologize for that, but I will talk about him in this and future episodes because he is also a sponsor of the show. And the person I'm talking about is a guy named Mark Purvis. Now, Mark is a videographer, so he does videos, and actually you can see a lot of his videos if you go to the Yesner Law YouTube page. There's a certain series of videos that has me standing in front of sort of a bluish, sky bluish background, wearing a suit with a blue tie. Mark did all those videos. He produced them, he shot them, he edited them. He had the teleprompter there for me to read from. It was a great experience. Those videos are still getting hundreds and hundreds of views. And so some of them that I've done with Mark, how does a foreclosure affect the sale of a home? What happens to the home if one spouse dies? I did a little teaser video for this podcast. There's another video up there that I see, how does bankruptcy affect the sale of a house? So if you're interested in creating video content, Mark would be a great person to reach out to. The name of his company is Real Time Productions, and you can visit his website at www.realtimetelevision.com, realtimetelevision.com. So thank you, Mark. He is a now formal sponsor of the show, and Mark has been doing all the sound editing on this show literally since day one. So the fact that you don't hear a lot of background noise, the fact that you don't hear a lot of the ums and ahs, the fact that you don't hear a lot of the pauses maybe sometimes when I'm asking a question and the guest is answering the question, all of that is attributable to Mark. So thank you, Mark. Thank you, Real Time Productions. And if you all need any audio or video editing, please reach out to me or reach out to Mark through his website, realtimetelevision.com. So I wanted to give you an update. Last week I talked about that I was going to be, or I was at, the Judge Alexander Paskay Memorial Seminar. Judge Paskay was a judge here in Tampa when I first started practicing bankruptcy law. Actually, Judge Paskay predates even the bankruptcy code. Judge Paskay was, I believe, a magistrate when the bankruptcy code was still called the Bankruptcy Act. And he's written a lot of the code or wrote a lot of the bankruptcy code. He's taught on the bankruptcy code. Judge Paskay is probably forgotten more about the bankruptcy laws than I will ever know. Now, he did pass away, I think, around 10 years ago is what they said at the seminar, but a great man, a great judge, very, very smart, very, very quick-witted, and used to sponsor this seminar that was here in Tampa last week. And so when he passed, they named the seminar after him, the Alexander Paskay Memorial Bankruptcy Seminar. But we learned a lot of stuff at that seminar. It's always a fun seminar to go to, and I always learn and get to remake some connections. Now, I'm not going to go over what I learned. I'm still digesting some of it, and so I've got to sort of get my thoughts in order here, and then I'll do an episode of pretty much what I learned that might impact you as a listener But some of the stuff we talked about in the seminar, some of the stuff I'm going to kind of put together in my own head and bring back to you. Things like IRS, new rulings coming out in terms of what the IRS can and can't do. Student loans, there's been a lot of talk about student loans. Now, as I record this, as you listen to it, it's the beginning of April. We've got a May 1 date of when bankruptcy payments are going to come due again. Now, we sort of think maybe that deadline is going to get extended. And so student loans will continue to be on deferment beyond May, probably beyond the midterm elections. But right now, the moratorium on collection of student loans is about to stop May 1, which means May 1, all of you that have not been paying your student loan payments, it may come time to pay the piper. We'll see if it gets extended again. We had another discussion in this bankruptcy seminar about TBE, or tenants by the entireties, basically the husband and wife exemption. So if you own property with your spouse, quote, as husband and wife, there is a specific exemption that applies to you under Florida law, and there's been a handful of cases that have talked about the interpretation of that law here recently, so I'll bring all those to you as well. But that's not really what I wanted to talk to you all about today. I'll talk about some of that stuff in later episodes. What I wanted to talk to you about today is something that's happened here in a lot of my bankruptcy cases, and it happened today, and it happened a couple of weeks ago. First time it happened to me was years and years and years ago. And the way the situation came up, I had a realtor. This was back in the crash, back in the days of short sales, and this realtor literally was making no money whatsoever. I mean, couldn't squeeze out a closing if he had a family member selling property. I mean, it was really, really bad. He was making no money whatsoever. And so he came to me because his debts were crushing him and he wanted to file bankruptcy. So we put a bankruptcy petition together and I filed it. Now, I got challenged by the United States trustee. And the reason I got challenged by the United States trustee is because this particular borrower, this particular debtor, was in a same-sex relationship with another man. And again, great guy. I'm not saying anything's wrong with that. It was totally fine. Both of them are fantastic guys. I still talk to them today. They're both fantastic guys. At the time, they couldn't get married. It was not legal for them to be married in the state of Florida at the time. So when I filed the bankruptcy, I thought, well, he doesn't have a spouse. He's not married. Now, his significant other was literally making a six-figure salary. And so I file this bankruptcy for the realtor that's making nothing, and I get a challenge from the United States trustee because the United States trustee is arguing that bankruptcy is based on household income. And since there were two of them in the house and the one guy made over six figures, that the one who was filing should not be able to file a 7. He should have to file a Chapter 13. And I said, well, wait a minute, that's not fair. They're not married. And the U.S. trustee's response was really, well, so what happens if the realtor, the debtor, the one who filed bankruptcy, doesn't bring in any money to pay the electric bill? Is the one that makes six figures going to let the lights get turned off? Well, no, that's foolish. He would pay the electric bill. U.S. trustee said, well, what if the realtor has a really bad week, bad month, bad quarter, and doesn't have any money to buy food? Are they going to starve? I said, well, no, the one who makes six figures will buy food. And U.S. trustee kept going on with those kinds of analogies and finally said, look, it's household income. Because even though you may say that one spouse is responsible to pay the mortgage payment and the other spouse is responsible to pay the food, if one of them doesn't, the other one's not going to let them get kicked out, not going to let them go hungry, not going to let the cable get turned off. They're going to go ahead and pay it. They're going to support their significant other. And I said, but they're not married. The U.S. trustee said it doesn't matter. How many of them live in the house? And so from that point forward, that's the analysis that we have to undertake in every bankruptcy case. In other words, is there somebody in the house who's making money that together they make so much income that this would have to be a Chapter 13 repayment plan? Or can the spouse or the individual who's filing alone, can this person just file by themselves and say, I'm destitute, I have no money, I can't afford to repay my bills, I don't have a job, I'm not getting unemployment? And unfortunately, I think the answer is we've got to take both incomes into account. Now, a lot of times, this answer is kind of obvious. In the situation that I had with the realtor that makes nothing and the significant other who makes six figures, and I think they are married by now, but the realtor who makes nothing and the significant other, now spouse, who makes six figures, had this come up today with a client. The client literally makes nothing, $500 a month by doing side jobs and side projects here and there, but has $4,500 a month in expenses. And so I literally said to him, how do you survive? You have 500 coming in and you have 4,500 going out. How do you possibly manage that on a monthly? After the first month of that, I would be done. How do you do that? And he said, well, I have a fiance that he hadn't mentioned before. And so part of this issue is due diligence as well. We have to do our due diligence to make sure that the client, the debtor, is being responsible and being honest and being an open book with the bankruptcy court. And so once we started talking about, okay, so you have a fiance. Does your fiance live with you? Well, yes. What does your fiance do? She's a realtor. How much does she make? 6 figures. And so we're right back to the situation of the first example I brought up, where this poor guy makes absolutely nothing. His fiance brings home 6 figures a year selling real estate. Well, my client doesn't have the money. It takes my client 3 months to save up enough $500 payments to pay the rent. And that doesn't include if he has to buy food, electricity, telephone bill. I mean, you name it. So his fiance pays all that stuff. Well, now we've got to adjust the budget. Now we've got to adjust the means test. Now we've got to start getting the non-filing person's pay stubs. We have to start getting their bank statements, because what we can do is we have to include their income. Now we can also include any expenses that they pay. So does this person that pays her own expenses? Does she have her own credit card bills? Does she have her own student loans? Does she have her own car payment, her own insurance payment, her own health insurance payment? What does she pay in taxes? All of these things we can take into account so that combined, even though she may make 6 figures, if combined they're at a break-even point, now we're back to my individual client being able to file a Chapter 7. And again, the interesting thing is they're engaged. They're not married, just like the same-sex couple that I made an example of here a few minutes ago. They were not married. And so I think the issue is how many people live in the household. Now, what I've always said is how many heads on beds at the end of the night? How many people are sleeping there? Is it 2? Is it 3? Is it 5? Is it 1? How many people are sleeping there? Now, the good news is the more people that are in the house, the higher the median income is. So when we talk about the means test and how do we calculate what's owed under the means test, well, the more people that are in the house, the higher that number becomes. Now, again, if you have somebody that's knocking it out of the park and making 6 figures, it may not matter how high the means test is. But one of the tests we use to determine if someone can file bankruptcy is what is their income as compared to the median income for their household size in the state. So again, this particular couple that I was talking about earlier today, where the guy said, yeah, I have a fiance. Well, in questioning him about his fiance, I learned that she just gave birth to their child. Now there's 3 people in the house, not just 2. And so a situation that may have been worse because the fiance was making a lot of money now becomes a little better because there's a third mouth to feed. So we can increase the food expenses. We can increase the medical bills, the medical expenses. We can increase the means test. All that kind of stuff can go up because now there's a third mouth to feed. And so we want to ask questions about how many people live in the house. Had another consultation, as a matter of fact, today with another client. This woman is a widow, and her 21-year-old daughter lives with her in the house. Now, her daughter is, I think, a waitress somewhere. And I had another couple that filed bankruptcy, and their daughter was a waitress somewhere. And so we had to include the waitress's income because, again, she contributed to the house, especially with this other client that I was talking to earlier today. And I said, well, does your daughter pay you rent? Well, no, my daughter doesn't pay me rent, but my daughter pays the electric bill and my daughter buys the groceries. Okay, well, now we're going to have to include the daughter's income in terms of your bankruptcy petition, but now we get to increase the number of people based on the means test. And now it looks to the trustee a more accurate picture of here's how much money is coming into the household and how much money is going out from the household. So again, it doesn't have to be a scenario where it's a married couple. It could be a same-sex couple. It could be roommates. It could be parent and child or parents and children. Now again, if you've got a 10-year-old and a 12-year-old, obviously they're not working, so we don't have to include their income, but they count as people, heads on beds, for the means test. So now we get a family of 4. where maybe you've got a husband and wife working with a family of 4. So again, how many people live in the household? Bankruptcy is based on household income. Now, here's the other interesting thing. A lot of people worry, well, why do you need my fiance's income? Why do you need information about how much he or she makes? Why do you need bank statements? Why do you need pay stubs? Why do you need this? Why do you need that? Well, again, it's to determine how much money they make, and it's to determine the size of the household, and it's to determine the means test. But it does not mean that this non-filing person, non-filing significant other, non-filing spouse, non-filing child, it does not mean that this person is filing bankruptcy. We just need to send this person's information to the bankruptcy trustee and to the United States trustee, potentially. But it doesn't mean that this person is filing bankruptcy. So again, going back to the very beginning, the situation I had with the realtor and his significant other that was making 6 figures. Well, under no circumstances would that significant other have been considered as having filed bankruptcy. Go back to the example I just gave you of the widow and her daughter. In no circumstances would the daughter be considered as having filed bankruptcy. The example of the fiance. Under no circumstances would the fiance be considered as having filed bankruptcy. So we can provide this information to the bankruptcy trustee without the person that is not filing being included in the petition. So there would be nothing linking them to a bankruptcy. We're not going to report their social security number to the bankruptcy court or the bankruptcy trustee. All we're going to do is show them pay stubs, bank statements, and other financial information to show how much are they contributing to the household. So, for those of you that are wanting to file but don't want to get your spouse or significant other involved, know that the worst I'm going to do is ask for you to provide me with their pay stubs and financial information. I will not make them sign the petition, and they will not be filing bankruptcy. Now, again, you may want to consider the 2 of you filing bankruptcy together if, number 1, you're married, because we can't file a joint case for people who aren't married. So number 1, if you're married, you can file a joint case. But number 2, if you have a lot of joint debt, because the problem here is, let's say me and my wife have a joint debt and I file bankruptcy alone. Well, my obligation to pay that debt is eliminated. My wife's obligation to pay that debt remains. So let's say my sister and I are joint on some debt and we do a joint credit card or whatever. And again, I file bankruptcy. Well, my obligation to repay that credit card is eliminated. My sister's obligation to pay that credit card remains. So in a situation where I would file bankruptcy, she would also potentially need to file bankruptcy to get rid of that credit card debt where, it's my sister, so we can't file jointly. But if it's my wife, we file jointly, and now the obligation to pay that credit card goes away for the both of us. A lot of times that's why I'll say that a great referral for me is an amicable divorce or a divorce attorney, because a lot of times if the parties are amicable about their split, until they're divorced, I can file bankruptcy for the both of them as a joint husband and wife couple, eliminate the debt for both of them. Then their divorce becomes finalized and they go on their separate ways now without the debt burdening them. Now all they have to do is worry about kids if they have any, pets if they have any, and the property split. I can get rid of all the debt. Now, if they're not amicable, that's different. And to sort of relate it back to the topic here that I've been talking about, here's the interesting thing. What if you have a couple who is separated or separating, but because of the finances, because of the cost of finding a place to rent, they live together, but one lives in one bedroom, one lives in another bedroom, and they really don't talk to each other. They don't share food. Maybe they'll split common expenses, but that's about it. One has his section of the refrigerator, the other has her section of the refrigerator. Or even if we were to do this in my house, which we're not, my wife and I have a great relationship, but even if we were to do this in our house where I have an outdoor beer fridge, well, one of us would have the fridge inside, one of us would have the fridge in the garage or something like that. Would we have to include that person if the other filed bankruptcy? So if you have a separated couple, would we have to include both of their incomes and both of their financials, even if only one had to file bankruptcy? And I think the answer there is the typical attorney answer, it depends. So again, if this is an amicable couple that is splitting expenses, yeah, we might need to get the non-filing person to provide us with pay stubs and bank statements and all that stuff so we can figure out what the household income is for purposes of the other one filing bankruptcy. But under the bankruptcy code, under the budget, under the means test, there is a process. If you are married but separated and you know nothing about your former spouse. Had a couple call me the other day. They'd been separated for 9 years and they didn't even know if the other person was even still alive. They lived in a different area, in a different state, but they were married. Well, in that case, we could file bankruptcy just for the one and not include any information about the other because they're not sharing any expenses. And we don't know how to get the information. We're not getting money from the other person. We're not splitting expenses with the other person. Literally, there's no connection to the other person except a piece of paper that says they're married. Now, my advice is to go and get a divorce. But absent that, I think that's maybe one of the few scenarios where we would not have to include the non-filing spouse in the filing because they're so separated and so apart from each other that they don't share any common expenses. No one pays the other any kind of money, any kind of child support, alimony, nothing like that. And so I think in a situation like that, even though they're married, we would not have to include the spouse's information for purposes of the bankruptcy. So I think that's going to do it for this week's episode. A little bit of a shorter episode this week. Got some interviews here lined up over the coming weeks. I'll record some more content for you as we go here. I'll circle back around to the Judge Paskay Memorial Seminar and pull some of the information out of there that I think is relevant for you and see if I can't break it down into regular English, but rather than legalese we lawyers tend to talk about. And then again, special thank you to our existing sponsor, Sam Cohen of Attorneys First. Very special thank you to Mark Purvis of Real Time Productions for all of his work in editing the show since episode 1. He's been our editor. So thank you, Mark. Thank you, Real Time Productions. If you want to contact Real Time Productions about editing for you, it's realtimetelevision.com. So other than that, I think that will do it for this week's episode of the Crushing Debt Podcast. Like I say at the end of every episode, I hope that at the end of the month you have more money rather than at the end of the money you have more month. That'll do it for this week's episode, and we look forward to talking to you in next week's episode of the Crushing Debt Podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.